contempt. We respectfully challenge jurisdiction.
Court has jurisdiction.
We reserve all rights to appeal.
Judge ordered that you not do certain things, you continue to do them.
Mama's House Ministry running on a private contract. I filed special occurrence papers. The judge ignored it. It's called sovereign gibberish.
They're gonna file a petition for criminal contempt. I can put you in jail.
This is not your everyday SovCit trial. Oh no, these two folks, the Yoders, are Amish. The Amish are basically the OG of sovereign citizens. They preceded the Moorish sovereign movement by a good 200 years. As a rule, they don't welcome the English, as they call us, into their daily lives. They especially don't welcome government intrusion into their society, and they have historically resisted, kicking and screaming, any modernization of code and law that affects their interests. Today's case is the culmination of years of fighting between the Yoders, who are illegally operating a birthing center, and Colon Township, who presumably had a legitimate zoning argument against the Yoders. A judge previously granted an order to cease and desist. The Yoders didn't. Instead, they changed the name of their outfit and kept on pushing. Now they want to contest the zoning decision, but as Judge Middleton so eloquently put it, that ship sailed. Let's roll, nerds.
Good morning. This is the time and date for a hearing regarding a show request regarding a alleged violation of an order from Judge Stutzman. Both are entitled Colon Township versus Alfred and Joanne Yoder. Are you Alfred Yoder?
Yes, sir.
And you're Joanne Yoder?
Yes, sir.
Mr. Lance Thornton is here on behalf of Colon Township. Some of the rulings that are at issue today have already been decided by another judge. The question is the compliance with that judge's order. So now I'm the judge's hearing it. The township moved to disqualify me. I denied that motion, and so we're all here. I recommended sincerely that the defendants get counsel in this matter. They don't have to. There are some complicated issues here. There are some consequences of the findings. And it's my understanding, Mr. Yoder, that you don't wish to have an attorney here at this proceeding and you wish to represent yourself.
We're currently getting advice and guidance, but we do not have a formal attorney representing us in the court at this time.
All right. Ms. Yoder, you concur with that? All right. And my concern was that I don't think the advice and guidance you were getting was very good advice or guidance. But you're of your own free will and you can make those decisions. All right.
Your Honor,
Yes?
before the court proceeds to contempt, we respectfully challenge jurisdiction. Jurisdiction must be proven on record first.
Right. Your objection to challenge jurisdiction is denied. The court has jurisdiction. You reside in the state of Michigan. I reside in the state of Michigan. I'm duly elected by the electors of St. Joseph County, and I serve under the leadership of the Michigan Supreme Court. This is a constitutionally and statutorily created court. You're residents of Colon Township. Colon Township is the plaintiff in this matter. You're the defendant, and the court has jurisdiction. So that motion is denied. Anything else you want to say before we begin?
Yeah, Your Honor, we respectfully note our objection for the record and reserve all rights to appeal.
That's appropriate. And I'll note any objections you have to the ruling I just made or any other rulings. And you do have a right to appeal. The appeal from this level would be to the Michigan Court of Appeals. So I respect that. In civil contempt, you don't necessarily have a right to have an attorney to represent you. You certainly can hire one. There's not incarceration possible as a punishment for civil contempt. There is a fine of up to $7,500 and other equitable relief, meaning the court can order that certain things happen. But if you're found in contempt, you're not subject to incarceration, at least not for this hearing. And the burden of proof is lower in civil contempt than it is in criminal contempt. It's a burden of preponderance of evidence. But essentially, the allegation is the judge ordered back in March that you not do certain things, and that you continue to do them. So the township filed a order to show cause. You didn't appear for the show cause. There was a bench warrant. You came in and we took care of the bench warrants, and now you're here so we can proceed. The township may call their first witness.
That I would call Joanne Yoder, Your Honor.
Chief Yoder, would you come up into the witness box? In civil contempt, you do not have a right to not testify. If you're charged in a criminal case, you have an absolute right not to testify. In a civil case, you don't have that right, and you're subject to being called by the opposing party. So, Ms. Yoder, would you come up here in the witness box, and then we'll see how we can proceed. Good morning. Would you state your name?
Sure.
All right, have a seat if you would. I know that Amish don't like to swear out an oath, so would you be willing to affirm that any testimony you will give here today will be truthful to the best of your knowledge and belief?
Under God, I testify.
All right, do you hereby affirm, not swear an oath, but affirm that any testimony you give here will be true to the best of your knowledge and belief? Well, let's see what we can do. Do you live in Colon Township?
Yes, sir.
Do you live on Marsh Road?
Yes, sir.
What's the number of the house? Okay. Thank you. And it's no fun to sit in a witness box. I've done it myself. I've had little small children in the witness box. But let's just try to do the best we can here.
In following up, Mrs. Yoder, with the two addresses you've confirmed on Marsh Road, the 8 Marsh Road, is that your home that you actually reside in?
Yes,
And then the Marsh Road, that is a second structure on the same parcel as your home, is that correct? You operate a birthing center in that second structure, is that correct? What happens in that second structure? Is it empty? Is it occupied? Who occupies it? Can you tell us a little bit about that?
ministry.
Okay. Can you elaborate on that? What do you mean by private ministry?
That's what we have as a private ministry.
Are there births occurring in that home?
It's a private ministry.
That's not my question. I'm asking you, do pregnant women give births in that second structure on that parcel?
My understanding, it doesn't matter what we do in our ministry.
Well, that may be your opinion. We'll determine that. Right now, we're just trying to establish what happens. And so you are required to answer the question.
That is part of it. But it's a private ministry.
Okay. So it would be accurate to say that the structure is used partly for pregnant women to reside there temporarily and give birth
Yes,
with the assistance of a midwife.
yes.
The use of that structure for births, did you used to call that Mama's House Birth Center?
So,
You never called it that?
no,
Did you have a name for it? Or do you have a name for it?
we have to be now, we did have
Okay. What's the name now?
Mama's House Ministry,
Was there a prior name?
Mama's House Birthing Center.
Okay. When did that change?
February 6th, when you had received all the documents of the change.
I missed it. February.
February 6th, 2025.
Okay.
And you received all of that. We have given you the documents on that. That was recorded here at the house.
My understanding, you had a DBA. Is that correct? Doing business as name.
Yes,
Okay. And so I'm correct. It used to be before February 6, 2025, Mama's House Birthing Center. And then after February 6, 2025, you changed the name to Mama's House Ministry.
It's,
The important date here on my next few questions is going to be March 13 of this year, March 13 of 2025. Because that is the date the default judgment and permanent injunction entered by the court. So let me start there. You did receive a copy of the default judgment and permanent injunction, correct?
I believe so.
And after that default judgment and permanent injunction entered on March 13, 2025, did you continue to allow pregnant women to temporarily reside at the 0 Marsh Road for the purpose of giving birth to their child?
Yes, yeah.
Approximately how many births occur there in a week's time?
It varies.
What does it vary from? What would be the low? What would be the high?
What is the necessity of this?
Well, I'm interested too. I don't know if they're having 1 birth a month or 6 births a week. So I'm trying to get a sense of it. Bear in mind, I didn't start this case. Judge Stutzman's heard some things that I have not. So I'd like to know the answer to that myself.
Probably approximately between like 4 to 5 a week.
As an average, would that be the case prior to March 13 of 2025?
Probably.
And would that be the case after March 13 of 2025?
Probably. Your Honor,
Yes.
may I speak for this before we go further?
Well, yes, what would you like to say?
The first court hearing, what he's talking about was all about Mama's House Burning Center. And there was, I've got proof here where that was all dissolved.
And so now it's Mama's House Ministry?
So that court hearing, what everything that they run through was all of default because there was no such thing.
Let's make a note of that.
Let me briefly respond, Your Honor.
Yes.
As part of this case, it's not the DBA that's the defendant. And it wouldn't be the DBA that would be the defendant. It's actually Alfred E. Yoder and Joanne Yoder individually as owners of the property that were made the defendants of this case and that were ordered not to allow the birthing center to continue on the property. So I guess it's the township's position that the change of DBA is irrelevant.
All right.
Your Honor, then the next thing also, so we received paperwork on the hearing, and in that paperwork, there's nowhere that it gave us to shut down. It says as soon as convenient, and that's not an appropriate time because it was never convenient.
All right, well, we'll explore that.
So the births that have occurred and are still occurring out there after March 13, 2025, a midwife assists with those births. Is that correct? You have to verbalize your answer.
Yes,
Are some of the women giving birth there on the property we're talking about after March 13, 2025? Are some of them unrelated to you?
they're for ministry.
But they're not a blood relative or a relative by marriage.
Some and some not.
Some are, some aren't. After March 13, 2025, are you charging the pregnant women that have birth there any fees for being allowed to use your property?
They donate.
They donate.
Some pay, some don't.
Do you have a established donation or a suggested donation?
Suggested.
What is that?
It's according to how much I guess how long to stay.
Kind of based on length of stay.
So,
Was it like a room rental fee?
yes, Your Honor.
Do you have any other fees or suggested donations for the pregnant women that come there to have birth, such as maybe for meals or things like that?
No,
That's included in the other donation you testified about.
no money for food.
You didn't catch that.
There's no money for food.
Okay. So the room rental you do accept.
Yes, Your Honor.
When there is a birth there, and again, I just want to concentrate now on after March 13, 2025. When there is a birth there, are you required to do any reporting as the owner of the property?
No.
So you're not required to report that a birth has occurred.
Have their documents for a birth certificate, that's all.
Okay, and that's what I'm referring to. So who prepares the documents that are necessary when a birth occurs on your property?
Midwives.
Do you have anything to do with that? Okay. So would it be accurate to say you prepare some of those reports?
Yes, I do prepare some of the reports.
Okay. And where do those, and these are reports of the mother's name, is that correct?
Yes,
The name given to the child,
yes.
the date of the birth, is that accurate?
Just a valid birth worksheet.
Okay. So anything on that worksheet you fill out or another midwife fills out, correct?
Yes,
Where do those reports then go?
Here.
Here, meaning to the courthouse?
yes,
Would it be accurate to say they go to the county clerk's office here at the courthouse?
yes.
How often do you make those reports?
Yes, whenever we have a birth.
Within hours or days, how often after you have a birth do you make that report?
They have it done within 5 days.
You deliver those reports to the courthouse by hand, in person, or do you mail them to the courthouse, or is it a combination?
Both.
Both. If I were to say that there's been approximately 87 births since March 13 of 2025, would you think that would be roughly accurate?
I have no idea.
Does it sound way too low, way too high?
Yes, I don't keep track. I don't know.
Can you tell the court why you're continuing to allow pregnant women to temporarily reside on your property and give birth to children in contradiction to the default judgment that entered in this case?
Well, number one thing, because our first court hearing was not appropriate. And number two, section 28, I've got the Michigan Constitution. I know you don't like it, threw it in the trash. Section 28, right to reproductive freedom. Section 28, every individual has a fundamental right to reproductive freedom, which essentials the right to make and effectuate decisions about all matters by compelling state interest achieved by the least restrictive means. Notwithstanding the above, the state may regulate, the state shall not penalize, persecute, or otherwise take adverse action against an individual based on their actual potentials. This section shall be self-executing, not provision of this section held invalid shall be servable from the remaining portion of this section.
The
Michigan State Constitution.
and just to clarify, Mrs. Yoder, it's not that I don't like the Michigan Constitution or the U.S. Constitution. I have a ton of respect for both. I just don't need to be provided a copy. I have copies of both and access to them. So
That's
the
very appropriate.
so it's I want to read you paragraph 3 of the default judgment. The defendants and their agents, servants, assigns, and successors in interest, and/or anyone in active concert or participation with the Yoders with regard to the operation of the birthing center are permanently enjoined from operating a birthing center on the Yoder property. Do you feel you're violating that paragraph of the order by continuing to allow pregnant women to come there and have births?
No, I do not.
Has anything changed?
Let me stop you for a moment.
Okay.
Paragraph 2 precedes paragraph 3, but she brought this up. Paragraph 2 states, Colon Township's request for injunctive relief is granted, and the defendant shall cease operation of the birthing center on the Yoder property as soon as reasonably possible. I think that had to do with perhaps you had clients that were in the process and he didn't want to immediately close it to leave some of those women with no prenatal care and no option for birthing except as emergency basis. Well, that was March. It's now September. And what you stated earlier is it isn't reasonably possible or won't be. Is that part of your argument too, that it isn't as soon as reasonably possible as of March 13th? How do you interpret that? And bear in mind, this is before I got here. Judge Stutzman ordered, stop doing this. And paragraph 3 makes that injunction permanent from operating a birthing center on that property. There may be some interpretation about what is reasonably, as soon as reasonably possible. I'm sure it's somewhere between March 13th and September 24th. Do you know when the last child was born there? How recently did you have a birth?
Your Honor, we made an agreement and I followed 10 commandments.
Has there been a birth there in the month of September?
So I don't remember the date that we was here. We made an agreement.
Agreement with God or with who?
I did not have a birth there.
All right.
So
Okay, so you don't right now know when the last birth was?
no, I did not.
Was it within the last 2 weeks?
Or whatever it was that we was here, that we made an agreement. That date was.
I'm not sure which date that is.
I think she was talking about the date of the unscheduled hearing
Okay, when they
were here at the courthouse and Your Honor contacted.
and that was August 29th. So you're saying there haven't been any births since August 29th?
Not there at that.
Okay.
Just to follow up on Your Honor's questions, how long is the normal stay of a pregnant woman that comes there to have a child?
Not more than 3 days.
How long before they actually come there do they normally contact you and make arrangements to stay?
Well, that vary on how you are, what you're after as far as when they realize they're pregnant or when they're in labor. That could be 9 months, or are you considering on when they start labor?
I'm trying to get at, when do you schedule them to be at your property to give birth? How far in advance?
Well, they usually schedule with us like 8 months ahead, a lot of them, 7 or 8 months ahead. But as far as when they're coming in, you can't decide on that until they're starting to have labor signs.
Until they would begin labor, correct?
Yes.
All right, so when they find out they're pregnant, they'll make contact with you to get in connection with your agency or ministry, we'll call it.
Actually, they don't contact me unless they're my patient. They contact the midwife, and the midwife lets them know.
All right. And then as you get closer to the date of birth, that's when they would come in. Sometimes you might not know till that day when they show up. Is that true?
Yes.
Did anything change in the operation that you have there as far as the pregnant women coming to give birth? Did anything change after you changed the name to Mama's Ministry?
Yes, we have a donation, and also they signed an agreement to be a part of the ministry.
Prior to the name change, you were actually charging, not a donation, but an actual charge. Is that correct?
Yes,
So after you changed the name, then you started accepting donations, if I'm understanding. I didn't catch that.
yes.
Do most women that use your property to give birth make a donation?
Most average.
What, is there an average amount that they donate
Probably on the average 400.
for their stay there?
Yes.
I'm going to take a few moments here, Your Honor, and see if I can locate the date of the show cause hearing in front of Judge Stutzman. Oh, let's see if I got that. I've got it. All right. In this case, Mrs. Yoder, we had a show cause hearing scheduled for July 2nd of this year at 9 a.m. And it was scheduled in the courtroom above us here in the same courthouse. Do you agree with that?
Said July 2nd.
Yes. The court had ordered you to appear to show cause why you should not be held in contempt.
Trying to think, because there was one of them that we made a mistake by not reading everything and found that after the court hearing, there wasn't even anything in my name. It was under, there was two forms we received. One was for Alfred F. Yoder and one was for Alfred E. Yoder, nothing for me.
Are you saying you weren't aware of the hearing?
I was aware of it afterward, but we did file special appearance forms. We had all of our information on there. You received it, you know. And the judge, there were special appearance forms here for you guys.
Are you saying you contacted the court and say, hey, I missed my show cause hearing, I need to reschedule? Is that what you're saying?
You have the information.
That's not my question. After you realized you missed the July 2nd, 2025 hearing, did you contact the court to let them know you missed it and you'd like to reschedule?
I turned in information here to give answers to questions because I cannot. I'm confused on which date's which.
Are you aware in the default judgment that entered against you and your husband that you were to pay some court costs to Colon Township? Were you aware of that?
Your Honor, can I answer that one for us?
Well, we'll see whether she can answer it, and then perhaps we'll get the answer from you if we need it.
I know I did see something with that, but being as it was all, there was so many confused things and so many things illegally written and illegally done. And plus it being under Mama's House birth center and not even having something like that existing, it being a ministry, I felt is all in default.
So it would be accurate to say you understood the court ordered you to pay some costs, you just decided not to pay them. Is that correct?
We paid something. I'm not sure. Was it that or what it was?
You each paid $1,000 cash bond, which is still being held. But I don't believe anything was paid other than that.
I guess otherwise I'm not aware of anything else that was in.
You have no recollection of paying either my office or going to Colon Township to pay costs in the amount of $265.48. Is that accurate?
I guess I didn't realize that that's not what the $1,000 is about.
So it's not what the $1,000 was about. The $265.48 were taxable costs ordered in the default judgment for you and your husband to pay. That's all I have for Mrs. Yoder, Your Honor.
All right, Mr. Yoder, thank you. You've done fine. It's not fun, as I said in there. All right, thank you. You can step down.
I would call Alfred E. Yoder as my next witness, Your Honor.
Mr. Yoder, would you come forward, please? Good morning, sir. Are you Alfred E. Yoder?
Yes, sir.
All right, I'm going to do the same thing that I asked your wife. I know you don't wish to swear, but will you affirm that any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I affirm.
All right.
I really want to concentrate on everything from March 13 2025 forward, that being the date that the court entered the default judgment and permanent injunction. You understand that, correct?
Yeah, I know what you were trying to do, but like she said, there's no Mama's House Birthing Center in existence on that date. And that's who you were filing against.
So would it be accurate to say, because you reside there on a daily basis, correct?
Correct.
So you're aware that after March 13, 2025, your property there continued to be used by pregnant women to temporarily reside there and give birth, correct?
Correct. That is Mama's House Ministry running on a private contract.
Okay. But you're aware that it continued to be used under whatever name it was given at that time?
Right.
Did you take any action to stop that type of activity?
No, because if you're running a ministry under a private contract, it's illegal.
So under that explanation, you would continue to allow that property going forward to be used as a,
There has been no births at that residence since I last talked with Middleton.
and that being towards the end of August
Correct.
of this year. You intend to resume births on that property.
Very good possibility, depending on what the outcome is.
Were you aware that you were to be in court for a show cause hearing on July 2nd of 2025?
I filed special appearance papers that you and the judge ignored.
So the answer to that
It's
is,
called sovereign gibberish.
okay. So the answer is yes, you were
Yes.
aware that you were to be there.
I did appear with my paperwork on a special appearance, and you totally ignored it.
Okay. Were you there in person before Judge Stutzman on July 2nd,
Negative.
2025? Did you say negative,
Right,
meaning no, you weren't?
right.
And were you aware that the default judgment and permanent injunction ordered you to pay Colon Township $265.48 in taxable costs?
No, because you were charging a business that doesn't even exist.
So would it be more accurate to say you were aware of it? You just didn't disagree. You disagreed that you owed it because of the way it was ordered?
The way I understood it, that is for Mama's House Birthing Center, and there's no Mama's House Birthing Center in existence anymore.
So you're not contending in any way, shape, or form that you actually paid Colon Township $265.48.
I did not pay him, no.
Do you have a role in the second structure on that property being used for pregnant women to come there and have births? I mean, do you regularly?
Honestly. I'm not starting seriously.
I'm asking.
I mean, are you the park their cars, or do you clean the rooms, or do you mow the grass, or anything that helps the operation of the center?
The only time I appear there is if something breaks down and needs to be repaired.
And you-
Otherwise, no.
Okay. So it's primarily your wife that operates it, correct?
She takes care of the building, correct?
Okay. She's also a midwife, correct?
Correct.
So she also helps take care of the pregnant women that come there to give birth.
Correct.
That's all I have for Mr. Yoder.
All right, thank you, sir. You may step down.
My next witness, Your Honor, would be Rhonda Schwartz. Where are you employed?
County, St. Joseph County Courthouse, clerk's office, deputy clerk.
Is one of the duties of the clerk's office to keep track of new childbirths?
It is.
Do you have a role in that?
I do a lot of the home births.
So you're the one within the office that primarily does it?
Yes.
I put two documents in front of you. Can you describe each one?
Yep. The first one is the live birth certificate worksheet. It says a local registered state use only. So this is what like a midwife would fill out. Or if the mom or whoever has a home birth, they need to fill this part out. So this goes to the state. This information is always go to the state, and we give the state a copy also.
Okay.
And the second one is a facility worksheet for the live birth. This has things like where was the child born? It's just, and the father can fill this out, or also the midwife or whoever attended, who was at the birth, a neighbor, whoever was there attended it. And they just have to verify that and fill out some information, if they know the answers to this. Some of it's medical questions. So, we also provide that for the state.
For each birth, do you receive both of those forms?
Yes.
These be marked, plaintiff's exhibits 1 and 2.
All right, Mr. and Mrs. Yoder, these are simply the forms that the clerk has described that you use. Do you have any objection to those being admitted as an exhibit? Mr. Yoder expressed no, and they are admitted.
So it's those 2 forms that your office takes in, the county clerk's office, correct?
That is correct.
And then what happens then, once you receive those forms, what do you do?
So then we go onto our state website and then we enter the information into them. And we also scan the forms into the state website so they have the actual form themselves. So then from there, we can generate a birth certificate if we have all the information on the worksheets.
And the birth certificates are essentially private documents, correct?
Yes, very good.
You do not hand those out to the public.
That is correct.
They have a lot of private information in them.
Yes.
As part of preparation for today, I asked you to prepare a report. Is that correct?
Yes.
More specifically, I asked you to prepare a report of how many birth records you had from Mama's House Birth Center and/or Mama's House Ministry. Is that accurate?
Yes.
And the time period I gave you was from March 13 of 2025 through the most current you had. Is that correct?
Yes.
And did you prepare such a report?
Yes.
And for the record, I'm going to hand the Yoders a copy of what I'm going to be handing Ms. Miller. Is that the report you prepared pursuant to my request?
Yes, we had, yes.
The births on this report, you have no question, are all originating from the Yoder's property on Marsh Road. Is that correct? So what does this report tell us? How many births were there between March 13 of 2025 and today's date?
Yep, a total of 79. It was 75 in the first one and 4 on the next page.
And what is the third or the single page births per week it's titled?
Yep, so this one just gives, from that date also, we listed how many births there was per week that we received. And this one has 8 pending. So this one has 87 total because there was 8 that we had to return back that we were missing some information on. So we turned those back. So that would have been, we didn't get those to the state. So that way that says 87 instead of the 79.
I'd move for admission. Those is one exhibit, Your Honor, plaintiff's exhibit 3.
Mr. and Mrs. Yoder, do you have any objection to the admission of the clerk's report? Hearing no objection, I'm going to have you mark this as exhibit number 3.
Since March 13 of 2025, have you had any conversations directly with Joanne Yoder regarding the births that are occurring on her property?
I do. If I have a question, if something's not filled out correct on the worksheet, I call her. It's just short conversation. She'll answer the question. And yeah, so probably about 3
Okay.
within that time.
Does Joanne Yoder sign some of those worksheets that you get?
Yes.
Does she sign most of them?
Yes, whoever fills that out, they're the midwife of that.
That's all I have, Your Honor, for Ms. Miller.
There were 2 births between August 31st and July or September 6th, and then none thereafter. Is that what the report shows?
Yes.
All right, thank you. Exhibit 3 is admitted. Do you either of you have any questions for Ms. Miller?
Negative.
All right, thank you. You may step down.
The next witness, Your Honor, I would call would be Joseph Klein.
Good morning, sir. You swear affirm.
State your, do you have a position with Colon Township?
I do. I'm their zone administrator.
How long have you been the zoning administrator?
6 years in June, I think it was.
Are you familiar with the Alfred and Joanne Yoder's properties on Marsh Road?
I am, yes.
Have you been to those properties?
I have, yes.
Have you handled zoning permit requests for those properties?
I have, yes.
As part of your position as zoning administrator, have you been inside?
Yes, on one occasion.
Approximately when was that?
It was a few months ago.
And is it accurate to say that the Yoders allowed us to come and take a look at what was happening there at that address?
Yes, they did. They allowed us to come in the residence and they spoke to us.
In preparation for today's hearing, I asked you to run what we commonly refer to as the fetch documents for the Yoders properties. Is that correct?
That is correct.
Did you do that?
I did.
All right, exhibits 4 and 5 are admitted. One describes the house of the Yoders and the building that houses the birthing center. One is a house just down the road, which houses a new structure that was under construction.
So question Lance had, Joe, about entering, that was against our will, very illegally done. But Attorney David Marvin was working with us. We had him helping us. And he knew that we wanted to work in peace. And so he said that he feels that if we let Lance come in and see for himself that this is all legal and everything is well taken care of, that we can work in peace. So that's the only reason we agreed, because we wanted to work in peace.
All right, this was,
We are still being harassed.
so this was in 2025,
Yes.
Negative.
2024.
No, this was before.
That would have been like December of 23.
All right, so at that time, David Marvin was the county prosecuting attorney.
Was right just before he moved up north.
I can confirm that I did have discussions with David Marvin about this matter. His official, he was communicating with me and corresponding with me. He officially said he wasn't formally representing the Yoders, but he was talking to them. But I would also state that any implication that Mr. Klein or myself, and I was there too, entered without permission or against their will was just inaccurate. We would have never entered.
Well, it may be a matter of perception, but obviously you weren't illegal entry. But Mr. Marvin was the county prosecuting attorney at the time this took place. He was county prosecuting attorney until December 31.
I would have to go back and look at that correspondence dates and those things. I don't believe so. I think he had finished by the time he started corresponding with me, and
So it would have been sometime after January 1.
to the best of my recollection, because I know he told me he was planning on moving up north at the time, and he was getting ready to.
Well, he didn't come to work for the last couple of months. He wasn't here maybe in November or December.
Could have been during that period of time. I would have to check.
Miss Yoder, you've got some input on this?
Sure, I was in January
Was it January? All right, that'd been after his term ended.
last year.
Oh, January of 2024?
I think so.
Probably. This has been going on for a long time already.
All right, well. All right. I guess it isn't crucial. I was just surprised that he would be, I didn't know if he was doing this in his role as county prosecutor or as advisory council, and whether he was still prosecutor or not. I guess it doesn't matter. The point is, maybe you weren't real pleased about it, but under the advice of Mr. Marvin, you let them come in and inspect the premises.
Your
So,
Honor, sir,
yes,
like she said, we tried to work in peace, work
okay,
with a little bit of common sense with these guys. And you can see how far we've got.
We did hire David Marvin for an attorney.
all right.
As we moved on.
Yes, he moved to Mason County, but I don't think he's there anymore. I'm not sure where he is now, but he's not here in our county.
Part of preparation for today, did you locate anything on social media to do with Mama's house?
I did look and see what was still floating around out there, and there is a main internet page that still says Mama's Birthing Center on it. You open the link, it does take you to the, I believe it's Mama's Ministry, Mama's Birthing and Mama's Ministry or something along that line for a title.
That has nothing to do with us doing something like whoever's doing that. If someone's looking on social media, there's a lot of false things out there.
All right, so
As far as that, I don't even own a computer.
all right, so you don't run a
So
website
I
for,
run nothing. I don't do no advertising whatsoever.
all right, thank you.
So whoever has that posted, I have no idea. Not got anything to do with me.
Mr. Klein, did you run a screenshot of what you found and where did you find it?
It was a local internet search, a Google search, and yeah, this was at 8:04 a.m. this morning that I located that, and then when I opened the link, it says Birth Ministries, Mama's House Ministries, and then it just goes on with the more literature and pictures of the inside of the building and whatnot.
I would move for admission that this is Exhibit 6. Just based it just solely on the, but it's out there on social media.
All right, well, for what it's worth, I take Mrs. Yoder's under oath. She doesn't run this website. Doesn't even really know about it, but apparently it is on there. If somebody was to do a Google search, this is what they would find. So for that purpose, I'll allow it, and it's admitted as exhibit number 6.
Is there a possible way we can find out who would have posted something like that?
Maybe somebody can. I'm not computer literate enough to do it. Facebook is
Deceiving thing.
I'm not on it, but it's a thing unto itself. For example, there is apparently a Judge Middleton Facebook page. I've never been to it. Somebody operates it, but I'm not really sure who it is. I don't look at it because I don't know. I don't want to know what people are saying about me.
I guess I can't see how that can be held against us.
Well, I'm not holding it against you. I'm just saying this is what would be found. For example, if somebody posts something on my Facebook page, I'm not responsible for it. Someone posted a picture. I didn't see it. My wife did, and Joanne were happy about it. A picture of me standing with another lady on the beach. I was wearing a winter coat. I had a picture taken with someone when I was walking down the street here in Centerville, and she photoshopped me and her on the beach in Florida or something, but I was never there with her. If I was in the beach in Florida, hopefully I wouldn't be wearing a winter coat. But anyway, yes, I'm not holding this against you. I'm simply noting that it exists. As far as I know, the people that go to my site are very kind. I don't go there myself.
That's all the questions I had for this witness, Your Honor.
All right. I have a couple. I'm late to the game here. My understanding is the gist of this is not an action by the State Department of Public Health, any issue of licensing. The state of Michigan or the Attorney General has no involvement in this case. This is simply Colon Township's enforcement action. Is that correct?
That is accurate.
And I don't know whether there ever was any, that's a question that's always, I've always had. Is there any sort of state licensing oversight here? But that isn't it. So the primary issue, or the is one of the issues, Mr. Klein, that there are two houses on the same piece of property?
No, that is allowed in Colon Township, under certain circumstances. I believe these meet that criteria. The problem is the zoning for the agricultural district doesn't allow for the.
All right, that was my next question. In many townships, you can't put two houses on the same piece of property. You can't share a well, you can't share a septic system. Each one needs their own. So that's not one of the violations.
Yeah, that is correct. Your
The
Honor.
crux of this is that that portion of Colon Township is zoned agricultural, and this is not an agricultural use, so it's outside the zoned designation for this property,
Correct.
which is what the whole thing rests on.
Primarily it's the use, yes. The use is just not allowed in that district.
Your Honor,
Yes, sir.
I'd like to have that somewhat explained, because Colon Township said you can't do it. No, I should say Lance Thornton said you can't do it. But if you go on the Colon Township map, and if you look for commercial businesses in the agricultural district, there's like 4 of them within 2 miles of them. That's like 2 acres.
Okay, that may be true. That ship has sailed. Judge Stutzman made a ruling on this that said you can't do it anymore as of March 13th. That's where I come into the game. I'm the zoning guy. You were at the hearing. At some point, the township didn't want me to handle this, and they asked me to be removed, and I denied it. I do zoning hearings in every village and township in the county, and I see routinely where I am doing a zoning enforcement case, but I know that 2 miles down the road is a property that's even worse. And I'm not dealing with that property. I'm dealing with the one that's in front of me. So I don't know whether there are other non-conforming uses out in the township that aren't before me. All I know is this one was brought to Judge Stutzman. The township argued that this enterprise does not fit within the zoning description for this parcel, and they're asking to enjoin it. And he did. He said, you can't do it anymore. And then they contend that you continued to do it after he said, don't do it anymore. That's what we're here now. I've said more than once, you could have benefited, and you could benefit from legal counsel. Mr. Marvin was apparently in the picture for a bit. So once the default entered, you would have had an opportunity to move to set the default aside or ask for a rehearing. Those things weren't done. That was in March. So that order stands. Judge Stutzman in a circuit court order says you can't do it. And you can't do it apparently because the township does not allow this sort of enterprise in that agricultural district. It isn't done, at least under these purposes, because they allege that it's unsanitary or it's not properly set up with well and septic, removal of medical waste, or any of those issues. It's simply, if your neighbor came and wanted to set a birthing center up across the street, the township would say you can't put a birthing center in that location. Apparently this has been here for a long time. There may have been some argument that it was grandfathered or preceded the zoning. I don't know about that. All I know is the order is in effect and it's not been set aside, and Judge Stutzman said you can't do it. And that's where we start. So you may have had defenses, but they weren't presented. apparently they aren't saying you can't do this, you just can't do it there. I was surprised that there is not some sort of state licensing requirement. That if I wanted to start Jeff Middleton's birthing center in Park Township, I could put up a building and do it. I had naively assumed that there needed to be some sort of state licensing to do this. But babies have been born long before there was ever any township ordinance or before there were even hospitals. So some of your views on this, I understand where you're coming from, but they weren't ever properly raised and they weren't ever moved to set aside the order. So the order's in effect and you have a right to appeal that to the Court of Appeals. But I think the time limit for that is probably passed. So you'd have to ask for leave. So you can't do this. This property is about as much in the middle of nowhere as you can get to in St. Joseph County. It's not easily accessible to ambulance or fire service. It's got dirt roads. It's in the middle of corn country. St. Joe County is about 74% agricultural. About 74% of the land is farmland. And you're right in the middle of it. About 5% of it is surface water. So the roads and the rest of us live in the other 20%. I guess they're arguing this should be, if anywhere, in the other 20%. And it's in effect, whether you like it or I like it, that's the order. Mr. Or Mrs. Yoder, do you have any questions for Mr. Klein?
Yeah, he's sitting there as a witness. And from my understanding, from the FOIAs that have been filled out, he doesn't even have a valid oath of office. And if you look in the Attorney General letter, it is my opinion, therefore, that the city building inspectors and zoning enforcement personnel are not authorized by law to issue and serve occurrence tickets upon persons who violate the building code or zoning ordinance of a city. It is my further opinion that city building inspectors and zoning enforcement personnel may not be empowered to do so by city ordinance or further position. That was from the Attorney General.
That's an interesting piece of information. Again, that ship has sailed.
He's sitting there.
Oh, well, he certainly can testify. Some villages and townships actually appoint their zoning administrators. And I think what they probably did is appoint his company as the zoning administrator. But again, that ship sailed a long time ago.
He's not carrying an oath of office. He's got no right to.
Well, you may have had a right to raise that objection some time ago, but the order's already entered. And you haven't moved to set it aside, and there's been no move to set aside the default. That hasn't been appealed. So that issue isn't before me. He issued you some citations. Now, very late in the game, you're raising this, which is one of the reasons why I've always believed you could have benefited from legitimate licensed legal counsel. Mr. Klein, you can step down. Thank you. I'm going to give each of the parties an opportunity now to argue what they think should happen. Mr. Thornton.
Yes, Your Honor, and my comments will be relatively brief. The Yoders made a decision to not participate essentially in this case when they should have participated in it and had the opportunity to participate in it and be heard. They then, after the court's default judgment and permanent injunction entered, and it's very clear that they were aware of that default judgment and permanent injunction. It was served upon them. They knew what it said. They then, because they disagreed with the decision, they intentionally kept violating the order. The births could have stopped much sooner. I'm not sure from the testimony given by the Yoders that they intend to permanently stop them at this point, but I guess we'll see on that. My point is that the Yoders contempt, and I think they are in contempt of Judge Stutzman's in this court's order. The township is going to request a fine under 600.1715 of $3,500 per defendant to get the point across that the circuit court's orders are that and need to be followed or legally contested.
And pay the original $243. Now I have $2,000 of bond money, which I can allocate toward fines and costs.
Yes, we still want the $248 or
Yes.
whatever it was. My understanding, the township gets none of that $7,000. So I would request, and the statute does provide for restitution to the township. I'm not prepared today to submit a detailed accounting of how much extra cost the township was imposed. I understand the township's not going to get its attorney's fees for the entire case, but it seems unfair to the township, to the missed hearings, the appearances I appeared for, the motion and order to show cause proceedings, the impromptu unscheduled hearing when the Yoders unexpectedly showed up at the courthouse, and then today's proceeding. I would like to request to the time to submit a request for the court's consideration to award restitution directly to the township for some of those extra fees and costs that they incurred.
That's generally called a bill of costs. As you know, I often, in fact, usually give any fine money to the township as restitution rather than keep it to the county. Zoning enforcement's expensive. All right, Mr. and Mrs. Yoder, their contention is that you violated Judge Stutzman's order by continuing to have births at your center. Now let's repeat. You changed the name of the enterprise from Mama's Birthing Center to Mama's Ministry. And it is a ministry. I guess I won't deny that. It's part of an overall worldview of things. But the ministry or Mama's Birthing Center wasn't charged. You were. It's in Alfred Yoder and Joanne's Yoder's name. So as Mr. Thornton argued, that name change is irrelevant, but it isn't really that easy. People do that. They're sued on a debt. They owe somebody money, and they change the name of the company and say, well, I don't owe the money anymore. That company doesn't exist. Maybe that might work sometimes if there's a corporation or something. The other thing people will do is they'll transfer the property to somebody else for $1. Somebody's got a horrific toxic waste site, and the township pursues enforcement, and they transfer it to their granddaughter for $1 or something, and argue we don't own that property anymore. Sometimes we have to parse that out. At any rate, this action is against the two of you. Judge Stutzman ordered back in March that you not have any more births at that center in terms of a permanent injunction. Doesn't matter what the name of it is, you can't do this at that place. And you had births through April, May, June, July, September, and I'll take it at your word that there weren't any births after August 29th and none in September. Obviously, your place is, well, if we've had 87 births in 5 months, you're busier than some of the hospitals. I suspect there weren't 87 births at Sturgis or Three Rivers Hospital during that period of time. At any rate, they did present sufficient evidence that you've continued to have births there in violation of that order of March 13th. So I find that you are in contempt. They're asking for $3,500 to make the point. I think the point is going to be made with the cost to the township of doing this. So we will set a hearing regarding the sanction after you submit a bill of costs. My inclination is to reimburse the township for their costs. That may be enough of a sting. And as I said, I do have $2,000 that I can apply to the fine and the contempt. I do fine beyond the required standard. Township has established that you're in contempt for continuing to hold burst through the summer at this facility. Now, let's talk about what happens next. He ordered that you can't do this there permanently. You don't agree with that and have not agreed with it, and you have a right to disagree with it. What you don't have the right to do is to continue to do it. If you continue to do it, they're going to file a petition for criminal contempt, in which case I can put you in jail for violation of the order. I could order under the equitable authority under the zoning law that the facility be torn down. I don't want to do that. And I don't want to put you in jail. I want you to stop. What you need to do, you obviously have a constituency. People like your service. I heard a number of people get up at the county commission meeting and say that we need this, we want this, and why is the government messing around with this? So you got people that want your service. You need to do it somewhere where you're allowed to do it. There are places that you could cite this that would not be in a zoning violation. The township says you can't do it here. That wasn't up to me. They filed the action. There was a hearing. Judge Stutzman made a ruling. Again, you had an opportunity to participate in your defense, but you didn't. So now we're all stuck with the order. You can't do this here. This isn't an order, but my recommendation is find some place where you can do it. Your followers will find you. We're going to set a second hearing regarding the amount of the fine. And Mr. Thornton will provide a bill of costs. You'll have an opportunity to object to that. Then I'll make a ruling on how much the fine is. We now have to deal with the other case.
I still feel that was very much, I mean, considering we had notified them, we had given them information about this is a private ministry, and being that would be totally out of their jurisdiction on doing anything like this against a private ministry. Before they made a court hearing, they had all this, and then Judge Stutzman lied about it. He said that we attempted to file our paperwork, and we did not. We did. It's all proven fact. It's stamped. It's dated. It was done February 6th.
Well, you can appeal these. His ruling has been made, and you did not move to set the ruling aside or appeal it. So it stands. If you had some defenses that could have been raised, they weren't. All right, we have the preliminary injunction. We're going to shift the record to the next case. That was the default judgment that entered. Request for default was filed by the clerk. And I did a preliminary injunction order in that case, which I'm pleased that the Yoders have attempted to comply with that since my order of August 29th. The order that Judge Stutzman entered had a reasonable time in it. That time is passed. So the date is September 1st. That date is passed, but there should be no further operation of Mama's House at this location after September 1st. 2025. So we're going to take out the reasonable time requirement. Let's shift to the new case. Mr. Thornton, request for default was submitted. I haven't seen any response. What's your position regarding that?
Your Honor, I would like to call one witness.
Good morning. Do you swear and affirm any?
And are you familiar with the Alfred and Joanne Yoder's property?
Yes.
And this has a fairly recently built quite large structure on it, correct?
Yes,
Approximately a 6,400 square foot structure.
yeah,
As part of preparation for today's hearing, I asked you to review Safe Built's entire file on this property. Is that correct?
yes,
Did you do that?
yes,
That two stop work orders entered on this property. Is that your understanding?
yes,
The first one entered on February 2nd of 2024. Is that correct?
yes,
And the second one entered on April 8th of 2025. Is that
Yes.
correct? No, you didn't post those stop work orders. Somebody else with Safe Built did. Is that accurate?
yes,
But you know that information from reviewing the file.
yes.
Can you tell us whether either of those stop work orders were ever rescinded or terminated by Safe Built or Colon Township?
No, they haven't been.
So they are still in place.
Yes. The only inspection performed there was footing inspection.
Should there have been other inspections performed?
Yes.
What is the kind of the status of that building?
Well, several inspections haven't been done. And I saw that when I went there. We should have had framing, insulation, whatever trades happening there, roofing and final. Those haven't been done.
Haven't been requested by the Yoders. So therefore the structure has not been inspected.
Yes,
What state is?
All right, let me start. That includes electrical, mechanical, plumbing inspections.
correct.
If we went out there today, what would we see? What status is that building in? How far along is it?
Final. It would be complete. The last time I was there was to post some documents on the door, and there was some siding that wasn't done and some site work that wasn't done.
But you viewed the inside of the structure through windows, is my
Yeah.
understanding?
And it's drywalled and the flooring is in complete.
And there is no and has been no building permit on this building for quite some time, correct?
Correct.
The former contractor that pulled the building permit terminated the permit, correct?
Yes.
In your opinion, or do you have an opinion as to whether this structure as built and as viewed by you the last time you were out there, is it built as a home or is it built as something else?
It looks like a healthcare facility to me. I opened up the drawings and looked at the floor plan. It looks like patient care rooms.
Is there a kitchen?
No kitchen. He's not in the drawings.
That's all I have, Your Honor. Again, that's in addition to all the verified allegations in the complaint that are considered admitted at this point.
Is there plumbing and bathrooms in the facility?
I'm not sure. I've never stepped into it.
Are they in the drawings?
I don't recall. All I looked at was the floor plan.
All right, thank you. Mr. and Mrs. Yoder, do you have any questions you wish to ask?
Yeah, I've got a little bit of a question on the affidavit for a search warrant. The fine or whatever they want to call it is signed by Lance Bonifield, and from the FOIAs that were requested, he's got no valid oath of office. And if you go back to the Attorney General, he's got no right. It is my opinion, therefore, that the city building inspectors and zoning enforcement personnel are not authorized by law to issue or serve occurrence tickets upon persons who violate the building code or the zoning ordinance of a city. It is my further opinion that the city building inspectors and zoning enforcement personnel may not be empowered to do so by city ordinance or charter provision.
What's the name of that opinion?
That's an affidavit for a search warrant.
No, the Attorney General opinion you just quoted from.
From J. Kelly,
Yeah, but what's the name of the parties?
Colon County, v. City of Gladstone, 305 Michigan, 50.8 NW 2D 908, 1943.
County of, what county is
And
that?
on that same,
What county is that?
PA.
Delta County, v. City of Gladstone.
also known as Happy Rock.
On the same affidavit for search warrant, it's a prosecuting official, Lance Thornton. I thought he's an attorney.
He
I
is,
think he's running two different deals on the same. And then if you go back to the search warrant,
And he doesn't have legal oath of office either.
we've got the officer as Lance Bonifield. If he's got no oath of office, he's an officer. So I'd say that whole thing's null and void.
all right.
I've got motions there. I'd like to have for you and Lance to have one of these.
Yes, would you hand them to bailiff? Yes.
If I could respond to what he said.
Well, you can ask him questions. We're not to the argument part yet, but if you have a question for him, you can ask it. Otherwise, I'll give you a chance to speak when we get there.
Sweet.
Motion to,
Motion to
Dismiss.
dismiss for lack of jurisdiction and violation of constitutional rights.
okay.
Introduction, defendant.
No, you don't need to read it all. I've got it here. Again, there's a timing issue. They filed this lawsuit. You had 21 days to respond. It did not respond.
We filed special appearance papers.
That's not an answer to the complaint. And then the time to answer has passed.
Yeah.
So, all right, yes.
So, as far as the responding date, so we did start getting things together to respond within 21 days. And then we were served more papers on this all being changed from Judge Stutzman down to you. And there was no response timing on that form. That's why we brought our response on the date of the hearing with our special appearance forms.
Mr. Thorne, what's your response?
The court rules provide that once the defendants are in default, which they are, defaults have been entered against both Mr. and Mrs. Yoder for failure to respond with a an answer to the complaint recognized by the Michigan court rules, that they no longer can participate in the defense of the action until that default is set aside. And that default has not been set aside. It's so I would object to any consideration of this motion filed here today. Is one, it's not a motion to set aside the default, and it's not been filed timely and was not served upon me and the township in time to respond to it. We can't be expected to respond to something we're given during the hearing. This case has been pending quite a long time. Also, the whole jurisdiction issue and this also oaths of office, they've cited some of these arguments before. The statute they're relying upon is Fourth Class City Act.
Yeah, the case that they were quoting from is a city case, not a township case.
And I believe the court's aware that there are different statutes and acts in Michigan that govern cities and townships. And I will represent as an officer of the court that the Fourth Class City Act does not have anything to do with Colon Township. The Michigan Constitution, Article 11, Section 1, really requires any official that is a legislative, executive, or judicial officer to be in oath of office. A building a code official in the state of Michigan is not an officer either of the legislature, executive branch, or the judicial branch. And there is no state statute that I'm aware of that requires a building code official to be to take an oath of office. And I know the Michigan Township Association backs that up.
Mr. Bonifield, you can step down. I'll accept this for filing. We'll set it for a ruling. Again, I got it like 3 minutes ago. I haven't read it. I'll make a ruling on it on October 15th at 1:30. Proceed with your motion for entry of a default
Well, Your Honor, based on our motion and the admissions in the verified complaint by having no answer filed and the additional supplemental testimony given here by Lance Bonnefield today, I move for admission of the default judgment and permanent injunction that was submitted with the township's motion and brief in support of that motion.
It is hereby ordered the plaintiff's verified motion for entry of default dated September 12th, 2025 is granted. The defendants or anyone involved in participation with the defendants are permanently adjoined from performing any further work on the interior or exterior of this building being constructed on the subject property unless a valid building permit is issued for the building by the building code officials and the stop work or orders have been rescinded by plaintiff's building code officials. I order that you're enjoined from occupying the building or allowing anyone else to occupy the building unless written authorization is obtained from the plaintiff's building code officials. If an occupancy permit is granted by the plaintiff using the building for anything other than a residential home for which zoning approval was obtained, this prohibits the use of the building by midwives and or pregnant women as a place to give birth in return for compensation, including room rental fees. This does not prohibit a woman from choosing to have a home birth in the building if that building is that woman's principal or permanent residence. I'm going to put in here rental room or fees or donation. No money damages are awarded to Colon Township. Defendants are ordered to pay $304.38 in taxable costs in relation to this motion. They shall be paid within 30 days from the entry of this judgment. From what I saw, that looks like a nice building, and it does look like a medical facility. I'm sure it could be used for something, but it can't be used for a birthing center. A lot of money was spent building this building without a proper permit and without inspections. Nowhere in the county can you do this, build a building without permits and inspections. So that's my order. All right, you give those to us.
Your Honor,
Yes, Ms. Yoder?
I would like to reappeal both cases.
All right, you can do that, but you can't do it by saying I appeal. Any more than you can say I divorced you 3 times and be divorced. You have a process you have to follow. All right, Mr. Yoder?
Just for the record, I guess, so you know, we had a building permit, we had a foundation permit, we had a zoning permit, a well permit, a septic permit, mechanical permit, and a plumbing permit.
Well, that was my understanding that it started out, it was.
Now, why, if they give me the permits, they had the prints that they could see exactly what that building is. They knew exactly what the square footage is of that building because it's right on the permit. I've still got copies of the permit. Once the building is all built, they say you can't do that. The thing of it is, mister, when we got to the point, my wife said, we got to do something different. She's going to need a new building. I said, all right, you go up, you find out what we need because the only place I can put a new building is in 2 acres of woods. So I'm going to have to clear 2 acres of my woods so my wife can put a house in there. I says, I'm not clearing woods before we've got permits. Ain't happening. So they give us all these permits. She talked with Joe from Safe Built and told him what she wants to do. And he told her how to fill out the permit. Okay. So we had the permits. The building is all enclosed. Yes, it's not going to weather from the outside. But all of a sudden they say, oh, you can't do that because you need this and this and this and this. Explain that.
I don't know that I have an explanation. I agree. This was started. You didn't just show up in the dark of night.
It's totally uncalled for.
All right. The problem is they filed the action, the default entered, and now you raise your defense.
We filed personal or special appearance papers on every court case that was filed.
So you have this concept of oath of office and special appearance papers. The court didn't accept those as a pleading. As again, you need legal help, real legal help, somebody with a license and some understanding. And I would encourage you to continue to get it. You've got a not what looks like the bones of a very nice building there, but you can't use it for the intended purpose. And you're right. They let you start this, and then somewhere along the line, the wheels fell off.
Well, how can they do that?
I don't know, but they just did. So, all right, we're going to be in recess. This matter is completed. You wait here. They'll bring you a copy of the order. You have a right to appeal it. We're going to have a further hearing on October 15th, where we'll determine what the penalty is, and I'll have an opportunity to review your motion and rule on it. If you want to file anything else, you can file it and schedule for hearing on that date. All right, we'll be in recess.